Welcome, everybody, to our continuing Vincent and Elkins energy series. This week, we are covering the recent developments in U.S. offshore wind. This is on the heels of kind of 2 weeks ago, not even quite that, where we covered the IRA Act as it existed from Senate passage, and now we have it going through the House, and we have not a signed bill, but we have it passed from both houses, and we're waiting on the president. So very exciting times. There is a lot in this legislation dealing with offshore wind. So this could not be more timely and just highly relevant for you all, just in terms of how you're thinking about offshore wind, the opportunities, the challenges, but it's all positive and going in the right direction. The speakers today, you have a terrific cast of folks speaking today, just covering kind of the broad spectrum of kind of offshore. We're going to be led off by Brandon Tuck. He's amazingly knowledgeable with respect to, everything in terms of the development, the NEPA process, everything that you're going to confront, just regulatory, in terms of developing a facility offshore. He's a wonderful resource. He's written frequently about it, as soon as as recently as last week. So he is immersed in what's going on in the offshore. Next up is John Michael. I refer to John Michael as kind of the dean of kind of maritime. You always kind of come away from anything that John Michael presents with kind of a better knowledge and insight as to what's going on with respect to getting things out to the offshore facility, getting it built, getting where it comes from, and getting it back on shore successfully. So you'll enjoy hearing from John Michael. After that, we have Lauren Collins. She's kind of my partner in arms here. Words cannot describe how talented Lauren is. She's a tax lawyer. She's been kind of incredibly kind of important, just in terms of us understanding what's in this new legislation and taking it from where it is now and kind of presenting it in the way that will make sense to you, and kind of the opportunities, the subsidies, which are a huge part of a successful development of an offshore facility. And last is kind of Josh Heidemann. Josh has been running with us for countless years. Anything that has been challenging and new and difficult to solve, Josh has been our kind of go-to corporate lawyer. He presents incredibly well, incredibly organized, can solve problems, brings just a wonderful perspective. And obviously with offshore wind, that is going to be critical, that everybody kind of understands everybody's issues and is trying to kind of get to the ultimate goal. So Josh is going to be incredibly valuable in success in offshore wind. So with that, I will step aside and I'll hand it over to Brandon, and we'll get started. Thanks, everyone.
Thank you, Sean. To kick off our slide, if you'll advance one more slide, I wanted to start with a little bit of color. I'm sure you've seen this graphic or you've seen one like it. Highest wind speeds are in the blue, red, purple range. Where are your eyes drawn? You can look at the center of the country and see from West Texas up through the Great Plains, some tremendous wind resources there. But this being an offshore discussion, I'm sure that your eyes are drawn to the coasts. If you look there at the east and the west coasts, you see some gorgeous thick blue and purple bands. One benefit is that those bands are pretty close to some of the dense urban centers where we have higher demand for electric generation. But there's still some bottlenecks, especially on along those shores. But we want to start off with these colors to say what they're meant to say, which is there's a tremendous potential for offshore wind. On the next slide, we've captured some of the more prominent task forces and commissions that have been put together, and some of the more visible reports and assessments that have been released. All of this is to take advantage of this great potential. Now, the next slide captures some of the forces that we see driving growth in offshore wind. And that main beginning force in the uptick in interest is political initiative. Now, likely everyone on this call knows about the administration's renewable energy growth targets. We hear doubling by 2030. We've become pretty familiar with last year's infrastructure law. That law set aside hundreds of millions of dollars to try to solve some of the transmission problems with developing wind resources. But there's some new items here. As Sean just mentioned, we have the Inflation Reduction Act. That's a different story, and there's a lot there to unpack, especially how that is going to help spur on project development. Now, throughout my discussion, and then a bit heavier in my colleagues' discussions toward the end, we'll pick up various facets of the the Inflation Reduction Act. But there's more around the corner. The last item on the screen right now, permitting reform. One of my favorite quotes, being a NEPA lawyer, someone whose job it is to try to help clients get projects built, is a quote from Judge Posner. I think it was 1990, so it's been over 30 years, where he said, when it comes to all the time and all the money it takes to prepare an environmental impact statement, that's the kiss of death to many a project. These days, if you go pick up a shorter form, more streamlined environmental assessment, it's still going to run hundreds of thousands of pages. Full-blown EISs, sometimes they're tens of thousands of pages long, and they take years. Each time we have a new administration come in, the administration brainstorms ideas on how to streamline and make permitting easier for their favorite types of projects, and sometimes how to ramp up scrutiny for other types of projects that don't quite favor. But wherever you are raising or lowering the bar on projects, it always has much bigger implications. We've read in the news very closely all the developments on the Inflation Reduction Act. We were delighted to see that it came with some permitting reforms as part of the compromise. Unfortunately, those permitting reforms weren't in the actual spending bill. They probably wouldn't make it past the parliamentarian review. But there's a compromise in place that led to Senator Joe Manchin's support. And so we expect there to be some congressional action on permitting reform. The common talking points for that permitting reform is that it's going to hit on some of the specific permitting and litigation risks that we're going to delve into here in just a few moments. But first, let's turn to the next slide. Let's look at a snapshot of where we are today. I put this slide together trying to capture just a handful of some of the biggest developments in recent months that are nudging us closer to this 30 gigawatts of offshore wind by 2030. We're going to start up in the top right corner, and then I'm going to go just very quickly clockwise around the horn. Great news, Vineyard Wind, South Fork Wind, the first large commercial scale projects out in the federal offshore, construction is underway for those. You move down into the New York Bight, and some eye-popping numbers on the lease sales there. We come down to the Carolina Long Bay, just as the administration was rushing to get some leases done before the Trump era moratorium went in place. Now we have the Inflation Reduction Act coming in, lifting that moratorium, opening up those areas. Down in the Gulf Coast, a couple of wind energy areas out for public comment. There's a draft EA for site characterization. And on the West Coast, we have some calls and a proposed sale notice off Oregon and California. And then another gem from the Inflation Reduction Act, the OCS leasing program being expanded to cover all of US territories, which will be a delight if anyone is looking to spend some quality time in the US Virgin Islands. Now you have another reason to go there. Let's flip to the next slide. and talk about how even though we have some of this political inertia and all this government activity going, it's anything other than smooth sailing. I'm going to focus on some permitting risk and some project opposition. And you'll see throughout these and through the discussions of my colleagues that we have a lot that needs attention and some hurdles to overcome. Turning to permitting, let's have the next slide. I'd like to do a little stage setting. Don't worry, we're not going to have a pop quiz on all the measurements on the right side of the screen. I like to show this slide because number one, it shows just how interesting and diverse jurisdiction is when you move offshore. But the main takeaway is that when you're in the offshore area, that primarily is subject to federal jurisdiction. That's where you have the Outer Continental Shelf Lands Act, federal leasing of lands under BOEM. That all happens out on the shelf beyond 3 nautical miles. And then on the other side, you have the uplands, onshore, which is primarily the subject of state jurisdiction and state permitting. You have some, if you have federal lands, you may have, or federal resources onshore, you may have some federal nexus there. But in between those, you have the coastal zone. And the coastal zone, you have an overlap of state and federal permitting. Let's flip to the next slide and just go through just very briefly a couple of the common permittings we have. And you'll see that we're gonna release a polling question to ask you where you think some of the biggest risks are in getting permits done. So BOEM, that's the agency that issues leases for development on federal submerged lands. They do that under OXLA, the Outer Continental Shelf Lands Act. Now, getting leases and whatever rights of way you need, that's just a preliminary step in getting an offshore project in development. BOEM, you're going to submit your site assessment plans and then your construction and operation plans, SAP or COP, SAP or COP. That process we're going to talk about in a few minutes ends up taking several years. We can also talk about the U.S. Army Corps of Engineers. Discharge of fill materials in the territorial seas and any wetlands or any onshore resources. That requires Clean Water Act Section 404 permitting. And when you're in any navigable water, you have to go through permitting to ensure that you're not obstructing navigation. That's called a Section 10 permit. Up next, we have the National Marine Fisheries Service, NMFS or NOAA Fisheries. You have to go to NMFS to get authorization when you need to construct or operate a project that might harass certain protected mammals, or go through the ESA Section 7 consultation for listed endangered or threatened species. On the right side of the screen, you see a variety of environmental reviews and consultations. Those aren't the names of agencies, but they are processes that the agencies have to go through, or consultations that the agencies have to go through before they can take an act and issue a permit. You can see there NEPA, ESA Section 7, essential fish habitat, cultural resource surveys. Those themselves are time intensive, and they have public notice provisions. They have substantive provisions that can extend the permitting time. Getting the results back on your polling, and interesting, we have a pretty good mix. About half of you think the biggest risk is BOEM. About a third think it's Fish and Wildlife and NOAA Fisheries, and then tailing is Corps of Engineers and Historic Resources, Section 106 issues. Thanks for participating in that poll. On the next slide, let's talk through some of the permitting that you might see in the coastal zone. In the coastal zone, it's a blend of state and federal agencies that have jurisdiction. On the federal side, BOEM doesn't have jurisdiction into the nearshore areas, but you still may need to bring your transmission cables in to be able to deliver your power onshore. But in this area, the Corps of Engineers does still have jurisdiction, and the Corps, they can't issue a 404 or Section 10 permit until they go through a couple of other permit programs where there's this program of federalism, where a federal statute gives states a role in the federal permitting scheme. We have on screen a couple of these federalism programs. The first is under the Coastal Zone Management Act. States set up coastal management plans, but the Corps of Engineers can't issue a permit unless the state says that that permitted project is consistent with the coastal management plan. You need a consistency determination from the state. Very similar program with Clean Water Act Section 401. Corps can't issue a permit unless the state certifies that that permit certifies or waives that permit or activity isn't going to impair the state's water quality interests. And so you have ways that under federal statutes, the states have decision making, but then the state itself is going to have myriad programs and requirements of its own. You're likely going to need to have state submerged lands, real estate outgrants or rights of way to be able to get through state-owned submerged lands, and then all of the other protections that states will have in the, along shores and dunes and other resources and refuge and park areas that they protect along the shore. On the next slide, we're going to turn and look at a bit at uplands. We've talked and written quite a bit in the last couple of years about the transmission hurdles and all of the upgrades that are needed to support this energy transition. We have offshore energy coming to onshore to deliver power. When that power is delivered to the state that is right adjacent to that offshore area, you're probably not going to have a problem. But you may have a problem when you need to have permit siting for transmission lines that go through states. And there currently isn't any federal backstop siting authority that trumps a state objecting to a transmission project. The Inflation Reduction Act tries to solve that problem, and it does it with the purse. In fact, it goes so far as to offer economic development grants to states and to local governments and to tribes that go ahead and facilitate, review, and approve projects. So that's one of the ways that the Inflation Reduction Act is helping to pave the way for a more efficient deployment of offshore resources. Let's turn to the next slide and jump back to federal permitting for a few minutes and talk about BOEM. Roughly half of you saw BOEM as the biggest permitting risk. For this slide and the next slide, we have a couple of colorful graphics that go through the steps of getting a lease and all the way through getting your project constructed, installed, and operating. On the left side of your screen right now, you see some calls, leasing notices, getting the sale, and then you finally get the lease granted. Once you get the lease granted, you enter into that little blue bar, which is you have a year to submit your site assessment plan. You get that site assessment plan submitted, BOEM reviews it, they send it back to you, approve you to go ahead, and then you can see in the green band, the little number 5, that shows you've got 5 years to get your construction and operation plan into BOEM. Now on the screen, you then exit that 5-year window into this orange environmental and technical review, and it suggests a year, and then you're into a decision to go forward and construct and operate. But if we look at the next slide, we can see that 7-year-ish range to get through the BOEM process, I'm just going to say it's a bit ambitious. This screen presents some of the same data in a different view. It just talks about the NEPA review process and what you need to have to go through to get BOEM to approve your project. So you get your year to put together your site assessment plan. You put that into BOEM. They don't just rubber stamp it. They're going to review it. They're going to go through the NEPA process, the ESA process, go through all the consultations they need before they can review it. There's no time on that other chart that accounts for that time. That other chart did give us a 1-year plan for BOEM's technical review, but that is pretty ambitious. Here we see 12 months for the review, but let's take Vineyard Wind as an example. They submitted their construction operations plan to BOEM in December of 2017. Now, it took BOEM a year to just publish the draft EIS, and then 18 months later, they came back out with a supplement to the draft EIS. Now, admittedly, there were issues to resolve. Being an early actor, they do have some more hurdles and bumps than what we hope we'll see out of BOEM going forward. But BOEM didn't eventually get its final EIS out until spring of 2021. So in other words, what we see here as a 12-month estimate actually took just over 3 years. On the next slide, we can see one of the reasons for these slipping permitting timetables, and that's that agencies don't have the resources they need. Now, I'm picking on BOEM just a little bit, but it's fairly true across the board. BOEM, the services, U.S. Army Corps of Engineers, they don't have all the staff to manage all of the incoming applications. One of the approaches is to throw more money and more staff at these types of projects. So BOEM is looking to give to increase their allocation and bring in 41 more employees to help manage this increased workload. The Inflation Reduction Act, it earmarks 40 million to CEQ and 30 million to EPA, or I might have that backwards, funding to those agencies to help address resource shortages. Though, if I may speak a bit candidly, I wish that money for those resource shortages went more to BOEM and the Corps, agencies that do more of the reviewing and approving projects, because I'm going to go out on a limb and say that EPA and CEQ getting more money is really just arming them to tell other agencies how to slow down their reviews and how to do their reviews differently than what they're doing. So said a little differently, the issue isn't just about manpower. It's about the entire permitting scheme and does it make sense? And that's where Senator Manchin comes in and where a permitting reform bill can come in. Now, there are some good opportunities for agencies to become a bit more efficient in getting through the environmental permitting review. One of them underway right now out in the New York Bight is that BOEM is kicking off what's called a programmatic EIS, where they're going through looking at the incoming wave of offshore development and figuring out now what they think the standard avoidance, minimization, mitigation, and monitoring measures should be. And so that later, when the applicants and the agency are working through the site-specific plans, they can adopt what the agency puts together. But there's one more aspect that I want to cover here, and it's going to lead into our next discussion, and it has to do with the point that you as a developer or an applicant are, where you say, agency, come on, I want my permit, issue it already. And there's some tension in getting quick and efficient issuance of a permit and making sure that the permit itself has jumped through all the hoops, that it reflects the agency's robust and comprehensive analysis of all of the environmental issues that they needed to have done. As counsel for project developers, we spend a lot of time helping build the record, helping sure that there aren't any gaps that opponents can exploit, and paving the way for more efficient and quicker reviews. But there are always challengers who are looking for ways to exploit some of those gaps. So let's turn to the next slide. I've drawn some examples from some of the recent challenges, mostly to Vineyard Wind and South Fork Wind. So if you look at who's bringing the suits, you see some breadth. The first, not surprisingly, are property owners onshore who don't want to see turbines on the horizon. They don't want to see new transmission lines going through their neighborhoods. It's also not surprising to see commercial fisheries that they oppose some projects, but also be on the lookout because there's some instances, one on the screen, of an onshore solar generator who doesn't want the competition from offshore wind to meet the state's renewable production goals. Let's turn to the next slide and look at some of the types of claims that these opponents make. Now, the environmental claims, they can bring them under NEPA, saying you didn't take a hard enough look at these environmental issues that we care about. On the species front, in particular in the New England area right now, there's the North Atlantic right whale, where there's only a few hundred of those whales left, and NIMS approved Vineyard Wind to disturb some of the areas where those whales nurse their young. So we have some of those substantive challenges to the permits, where you hope that the agency has done and has considered all the resources that they have, all of the information and the data on those resources, and they go through the right processes to make the decision. One of the claims that I want to spend the last few moments highlighting has to do with OXLA, the Outer Continental Shelf Lands Act. Now, that's the act that allows BOEM to lease these offshore areas for resource development. The act supports multi-use of the resources. And so for offshore winds, one of the biggest competing interests you have is commercial fishing. So let's turn to my last slide and take just a little bit deeper dive into the offshore commercial fisheries impacts for Vineyard Wind. They're going to put just over 80 turbines on an area that's 112 square miles. The actual surface area of the platforms is about 50 acres. So even with spacing these turbines a mile apart, the Corps of Engineers ultimately concluded that commercial fisheries are likely going to abandon the entire area because they won't be able to deploy their gear and then make turns. And so Vineyard Wind turned around and they came up with a proposal for roughly 30 million in compensation for the impacts to commercial fisheries. That offering wasn't enough, and we have some litigation over it. But I want to flag another open comment period at BOEM right now. Right now, BOEM put out some draft guidance for public review that explores different ways that you can think about how to best mitigate fishing impacts and how to calculate what those are in ways, and then deploy them in ways that can support offshore and commercial fishery uses of the Outer Continental Shelf. So as you can see, there are tons of hurdles that projects need to get through to make it through the government's permitting and review process, and then survive litigation challenges. I've only touched on just a couple of those challenges and a couple of the issues. One of the really interesting claims under one of the lawsuits against Vineyard Wind was that BOEM shouldn't have been able to even approve the project because there weren't any Jones Act compliance vessels available to go out and build that project. So this gives us a great opportunity to now turn some time over to my colleague John Michael, who's going to talk more about the Jones Act. Thank you.
And as you all might imagine, Brandon and I work very closely together, given how intertwined the environmental permitting issues are around our maritime and offshore projects. As a quick refresher, the Jones Act is a series of federal laws that take their name from the sponsoring Senator Wesley Jones of Washington State. They were passed around 1920, so we're dealing with a 102-year-old statute. And the laws require that for any product or people that are transported between two U.S. points be done so by vessels that are built within the United States, owned by US citizens, and crewed by US citizens. It's often referred to as very restrictive law, but it has purposely been designed as a restrictive law to ensure that the United States has a sufficient and ready fleet of vessels in the event of a time for war. Also, folks who complain about it need to understand that it doesn't just apply to US marine transportation and vessels. We also have similar regulations in place for the airline industry and the trucking and railroad industries in the United States. And I often tell folks, that there's a reason why you can't take a British Airways flight between Houston and New Orleans. And so the same principle applies here in terms of the coastwise laws of the Jones Act. Just last year, the Jones Act has been extended to offshore wind. There was some ambiguity within the Outer Continental Shelf Lands Act that Brandon mentioned earlier. And so Congress acted to close off that ambiguity and expressly extend the Jones Act to non-mineral resource energy projects out on the Outer Continental Shelf through the Outer Continental Shelf Lands Act. U.S. Customs and Border Protection is the federal agency charged with enforcing the Jones Act. They will issue rulings on brief requests that are submitted on questions of Jones Act applicability to a certain project or voyage or movement. And they also levy fines and penalties for Jones Act violations, which can be quite substantial and severe. Penalties range from anywhere from a thousands per dollars per day violation upwards of total forfeiture and seizure by the government of the vessel that's violating the Jones Act. So given the severity of the potential fines and penalties and the sensitivity of how the Jones Act applies, there's a lot of activity with customs issuing rulings and out there looking for enforcement of potential violations. Y'all know the old legal adage about a grand jury being able to indict a ham sandwich. In the maritime law space, we're focused and concerned about how to get the ham sandwich offshore to feed a crew that's working on an offshore wind farm. And believe it or not, there are actually requests pending and rulings that have been issued about how do you transport food and drinks offshore to feed an offshore crew working on a wind farm. So what does this mean for the offshore wind industry? If I could have the next slide, please. With the requirements of the Jones Act, the traditional model would be that turbines and other components needed to construct and install the offshore wind farm would be loaded at a U.S. port aboard a Jones Act compliant vessel that you see there in the middle of the slide. The vessel would then motor out to the installation site that is either within state territorial waters or out over the Outer Continental Shelf, and then offload those towers and blades and whatnot to construct the wind farm. The problem with this, as Brandon alluded to, is that there is no Jones Act compliant installation vessel available right now. There is one on order, only one, but she's not due out of the shipyard until the end of next year. So if we could have the next slide, please. Industries needed to get creative then without having a Jones Act compliant installation vessel and figure out a way that would still allow installation of the wind farms in U.S. waters, but make do with the vessels that are available. And the installation vessels that are currently available are all foreign flag, meaning they're not Jones Act qualified. They can't load any parts or pieces of the wind farm and take them out to the offshore installation point. So what happens is you see on the right-hand side of the slide, the foreign flag installation vessel will leave a foreign port and then arrive at the point in the U.S. waters where the wind farm is to be installed. And then from the left-hand side, you see coming out of the U.S. ports, the turbines and other components are loaded aboard vessels that are Jones Act qualified and compliant. So these are generally barges being pushed by smaller tugboats. that are all Jones Act compliant. So those small tugs and barges will then take the components they load out of U.S. port out to the installation site, where they rendezvous with the installation vessel. The installation vessel kind of hovers in place and then uses her crane, as you see in the middle of the slide there, to offload the component parts from the Jones Act qualified vessels and create the tower installation in the U.S. water installation point. And this is allowed because the installation vessel at no time is moving. So she has to either stay in place or hold herself in position. And she's merely using her crane to lift off the component parts and set them into the water. So Coast Guard and Customs do not view this as a transportation of these component parts from a U.S. port or point. The real transportation being when the tugs and barges that are Jones Act qualified loaded those out in the U.S. port and took them out to the installation site. And Customs a few months ago has issued a ruling that confirms this workaround using the foreign flag installation vessel is allowable. Next slide, please. I also wanted to touch on some recent Customs rulings regarding the Jones Act and how it applies to certain offshore wind activities. We've recently gotten new rulings out of Customs that affirm kind of longstanding practice that a foreign vessel can lay cable in U.S. waters between two U.S. points, and that is not considered a violation of the Jones Act because the vessel is merely paying out the cable. It is not transporting the cable between two U.S. points. On scour protection, the rulings have been somewhat mixed. There was just a ruling 2 months ago that Customs is coming down hard on its view that for scour protection, a foreign vessel can load the rock riprap material at a U.S. port and then take that offshore and lay the first layer around a tower or lay the first layer of scour protection before a foundation is even present on the pristine seabed. But the minute that first layer of rock or riprap for scour protection goes down on the seabed, that area then becomes a U.S. point. And so if more rock had to be brought out there, or if other scour protection had to be brought out there, some got eroded and you were replacing the scour protection, that would need to be done by a Jones Act qualified vessel, because Customs is saying then once the first layer is laid down, it becomes a U.S. point. Anything deposited on top of it from then on needs to be done by a U.S. qualified vessel. And then you kind of have a merging of these two rulings, and Customs also recently coming out with a ruling on cable protection. And they have found that the transmission cable laying on the U.S. seabed is a U.S. point. And so a foreign vessel cannot be used to then lay concrete mats on top of that cable to protect it. Anything going on top of the cable for cable protection needs to be laid down by a U.S. flag vessel that is picking up the cable protection mats from a U.S. port. So kind of a mixed bag of rulings, but the good thing I will say is once Congress has closed the loophole on the application of Jones Act laws to the offshore wind that's developing around the U.S. coast, these rulings have started to come out from Customs, and whether you agree with them or not, at least Customs is giving guidance and taking the decisions so that the industry knows how to move forward. And lastly, I'll say, as I introduce Lauren Collins for the next segment of our presentation, that our industry is very excited about the Inflation Reduction Act, which is going to be signed into law in just a few hours, because there is a special provision in the IRA that is going to allow for tax breaks and tax credits on the construction of offshore wind vessels, which we desperately need here in the United States. And with that, I'll hand it over to Lauren.
Great. Thanks, John Michael. Yeah, I mean, we are incredibly excited about this legislation. As Sean mentioned at the top, it just passed the House on Friday. So we had a deck ready for this presentation where we kind of set out, here's the current law and here the IRA is passed. We've scrapped that. So we're just assuming this legislation is signed, again, hopefully in the next few hours. So as of now, there's kind of two tax credits you would typically think about for an offshore wind facility, a PTC or an ITC. A PTC is a production-based tax credit that's available for 10 years. And it's basically, based off of the kilowatts of energy generated by a wind facility. So as you generate electricity, you earn credits. The ITC, in contrast, is a one-time credit that you get when you place the facility in service. So when that offshore wind turbine is, turned on and starts generating electricity, you accrue an investment tax credit for that facility. You can choose one or the other for offshore wind. You can't get both, but you can pick one. And it's basically just a business decision of which one will be more economically beneficial. Do you get more bang for your buck from a ITC or a PTC? So you'll need to kind of run those numbers to determine what makes the most sense. Given the cost of an offshore wind turbine, certainly in relation to onshore wind, ITC might make the most sense. That's kind of what we're hearing. Importantly, there is a recapture risk for the ITC. So as mentioned, you get it when you place the facility in service. You have to keep it up and running and you cannot sell it or dispose of your interests by more than 2/3 for at least 5 years. So the government wants you to kind of keep that turbine running once you've earned that tax credit, at least for the 5-year recapture period. So what did IRA do, or what is it going to do as soon as it's signed? It extends these tax credits significantly. Prior to IRA, they were already starting to step down, and the amount of the credit was reduced based off of when you were beginning construction. With IRA, both credits have been extended basically through 2032, if not longer, and I'll explain that. So the current ITC PTC framework is extended for anything that begins construction before the end of 2024. And then if you are in the post-2024 periods of 2025 and beyond, you switch to a technology neutral credit regime. For wind, this should not make a difference, right? You should be getting your PTC or ITC in the same amount, regardless of which credit regime you're under. So the way that I'm going to talk about them is as though they're the same. And I think for wind, we can assume that's the case. Those credits will then be available through the end of 2032, again, at least. The way the legislation is written, those credits are available basically until the later of 2032, or when we're able to achieve certain greenhouse gas emissions rates that are so beneficial as compared to where we're at now. So I think folks are expecting that those credits will actually extend past 2032. What's the amount of the credit? For the ITC, the headline credit is 30%. For PTC, it's based off of an inflated amount from 1992. Based off of our calculations, that's going to be about 2.75 cents a kilowatt, so I should say $2.75 a kilowatt hour. Then that inflates after 2022 based off of calculations that the Treasury will publish. That said, in order to get the full credit amount that I just walked through, you need to satisfy these new requirements that are pretty novel, certainly new to these specific credits. And those are two labor requirements. One is the prevailing wage requirement, and the other is an apprenticeship requirement. There's an exception to those requirements if you can begin construction on the project within 60 days of the date when the Secretary of Treasury publishes guidance on these specific requirements. I think we can all expect it's going to take some time for this guidance to come out. So we have time to establish that you've begun construction and been accepted from these rules. But that is something that folks will need to think about. If you aren't accepted from the rules and you are subject to the labor requirements, again, it's prevailing wage and apprenticeship. Prevailing wage basically just means that you need to ensure that anyone constructing or developing or otherwise maintaining the facility is paid basically Davis-Bacon wages. And these are wages that are published by the Department of Labor. They're published based off of locality and job type. And so you want to ensure that everyone is paid at least this minimum wage amount. The apprenticeship requirements are basically anytime you're employing more than 4 people, which I think for everyone thinking about an offshore wind farm, assume you are. You have to make sure that a certain percentage of the workforce or the labor force is qualified apprentices, and they're part of an apprentice program. The percentage is 10%, and then it steps up to 15% if you begin construction in 2024. And there is an exception if you've used good faith to find an apprentice and you haven't been able to. But you still do need to go through the process of trying to comply with this apprenticeship requirement. If you don't comply, there are cure options and penalties, but they can be costly. And so that was kind of the bad news. The good news, there is a domestic content bonus. This is also new in this legislation. Credit if you're able to establish that you basically produce enough of the turbine in the United States to qualify. So what does that mean? That means you need to manufacture or produce all of the steel and iron that's used in the turbine in the US. And then with respect to any manufactured component that is going to be part of the facility, here the wind turbine, you need to ensure that the applicable percentage of components has been manufactured in the US. And that's based off of cost. So the percentages are listed here on the screen. Starts at 20%, ratchets all the way up to 55%. So when we're in that highest kind of bucket, you need to make sure that the cost of 55% of the manufactured components have been manufactured or produced in the US. So turning a bit to these actual components and how they're manufactured, the PTC and the ITC that we walked through, that's really for the offshore wind facility itself. Again, it's either a credit for the production of electricity or for an investment in that facility. There's another credit that's available for the actual production of the components that make up the wind turbine. It's per component. You have to manufacture and sell the product in the US. It doesn't need to be used in the US, however. We've listed here on the slide the credit rates that are available. As John Michael said, this also applies to manufacture of offshore wind vessels, and that is 10% of the sales price that you get a credit for. Okay, so what do you do if you earn these credits, right? Traditionally, you've needed to either have tax capacity, or in other words, taxable income that you can use to offset with these credits, or you needed to engage in a tax equity financing transaction, where you essentially found someone to partner with who was able to benefit from these credits. And Josh will talk a little bit about this at the end, but it can be a complicated structure, certainly requires tax lawyers like Sean and I. So the government has provided in the legislation 2 new options in lieu of tax equity. That's not to say that tax equity isn't still going to be a big piece of financing these types of transactions, but it's no longer the only game in town. So the first option is direct pay. This was in the legislation that was originally being batted around late last year. but it's been revised significantly. So its import is probably, pretty limited, especially for folks on the phone thinking about offshore wind development. Basically, it's only really available for tax exempts or state or local governments. A few others listed here on the screen. If you're not one of these applicable entities, you're not eligible for direct pay for the ITC or PTC. It might be available to you for the advanced manufacturing credit, and that's that credit for production of components that we chatted about on the last screen. That one is available regardless of what kind of taxpayer you are. So the next option is transferability. This one is not limited in application, so anyone can potentially take advantage of it. And just put very simply, you can sell tax credits. So if you earn an ITC or you earn a PTC, if you find a willing buyer, you can sell that credit that you have earned to that third party. There's some complications and limitations, certainly, but I think we fully expect that this will be utilized in offshore wind and otherwise. It provides, like I said, not just an alternative for tax equity, but it can be complementary to tax equity because you could kind of do both in certain circumstances. So with that, I'm going to turn it over to Josh to put on some of the financing aspects.
Thanks, Lauren. And here, we're going to get into the key considerations for project financing and tax equity financing, just to kind of hit on Lauren's point. What we'll get to later, the transferability and what it opens up. There's two financing, especially tax equity financing on wind farms, and that's just the big ticket item, which requires a large club of tax equity, and also kind of just some of the complications with wind farms that are coming into service on a turbine by turbine basis, but still have construction debt, and just given some of the tax equity structures where the tax equity will come in at mechanical completion, and the options that transferability will give to either have smaller clubs, potentially have tax equity kind of take a piece of the credit as just a transferee, while still kind of being able to monetize the depreciation and the other credits. So key considerations, again, the extended commitment duration, as Brandon highlighted, just there's a long time from when you kind of get your lease until when you get your project operational. And obviously people want to get construction lending and get forward tax equity and other financing commitments. And there's just a long time. The construction risks, are significant, both from the environmental permitting standpoint, but also just, people not being as experienced with, U.S. offshore EPC and the like. O&M providers, Jones Act consideration, as John Michael highlighted, once you put that first layer score, it's now U.S. property. So anyone who's going to do any repairing of that, any repairing of the cables, any of that stuff needs to be Jones Act compliant on the vessels. Hopefully the tax credit that we're getting is going to help on that. Whether you set O&M and major maintenance reserves, those are going to have to be a lot higher than your typical onshore wind farm, just because of the vessel considerations and just the time and complications there. Sponsor supports, most of what we're seeing on these offshore are actually JVs, are combined sponsors, and whether one of those sponsors is stepping up or whether there's a sponsor from that JV entity, and making sure that there's credit supporting both the tax equity transaction as well as any debt that's supporting this on the construction side. Indemnities to tax equity investors, this is a common feature in tax equity investing. You have your cash sweep. Tax credit qualification, really Lauren hit on prevailing wage and that type of stuff, making sure that the qualifications. There's also, technology distinctions in all the different areas, whether you're offshore on the eastern seaboard or in California or in the Gulf, it's going to be different types of offshore wind. Let's go to the next slide. So, key considerations, I'm just going to go through these quick because we're at the end here. Site control, as Brandon mentioned, just, whether you got to get offshore facilities, you got to get your offshore leases, you got to get your onshore facilities, your revenue contracts, whether that's going to be a PPA or through an OREC. Right now, there's ORECs in New York, Maryland, New Jersey. There aren't those programs right now in some of the other areas that we're seeing development in the Carolinas, in the Gulf, in Michigan, off the Western coast. So, right now you'd have to get PPAs for those. It'll be interesting to see if those regimes end up adopting kind of something similar to what we've seen in New Jersey and New York on the OREC. And then the interconnect, whether you have multiple interconnection points. Right now, there's just not a lot of ability to interconnect the large scale of these wind farms. I think that's one of the things that we'll talk about here in the last slide, is just the size of these wind farms from a credit perspective and megawatt perspective are just much larger than what we're seeing onshore. And so there needs to be effective ability on point of interconnection and transmission lines to be able to take all that power that we're generating and being able to get it onto the grid. Next slide, please. So again, you got your EPC contract, whether you have a full wrap there or whether you're going to have a disintegrated contract approach where you have a, turbine supplier, BOP, again, O&M and other services agreements. This is going to be, really important both from the Jones Act consideration and just making sure that there's appropriate credit backstopping those entities. On the tax equity investment documents, wanted to spend, a minute here on this. Right now, one of the key problems that we've seen on this is just the structure of the tax equity for ITC. Generally, what we've seen is the offshore looking to take ITC. I think given what we've seen in New York Bight and just the lease amounts, we expect to continue to see these projects try to utilize the ITC. What that used to mean is that the tax equity investor had to be in the partnership prior to place in service. And so you'd have to come in at mechanical completion and there would still be construction debt. Also, you'd need to do that for each of the individual turbines, which could, go across several months or even years between when the first turbine is mechanically complete and when the last turbine is placed in service. So one of the real interesting and exciting things is transferability in terms of both, like I was saying, tax equity, signing up the deal, but maybe taking a portion of those credits as a transferee, tax equity signing up to the deal and agreeing to transfer those credits to mitigate some of the risk in between mechanical and substantial completion. One of the things we're also going to have to see as the market develops is just what financing lenders on the debt side are willing to do on forward commitments and whether we can see some type of product that emerges similar to what we have right now with an ITC bridge loan that is used for forward transferability credit. So if someone commits to buying that ITC, whether the lenders will be able to get comfortable lending against that type of contract. But the transferability really is going to be something that from a structural standpoint is going to be super exciting in the space and lead to lots of new innovations and structures that we're excited to kind of work with you guys all to develop. Next slide. That's the end of our presentation. I think we're already running a few minutes over, so we won't be able to address questions on this presentation, but we'll follow up with all those people who asked questions. And thanks to all of our presenters, Sean Moran, Brandon Tuck, John Michael, and Lauren Collins. And please reach out to all of us and any other members of the E&E team with any questions on anything relating to offshore or Inflation Reduction Act. We're super excited to continue to kind of work with you guys and move this forward.